Hi there, my name is Paul Heaton. I'm a professor of law at the University of Pennsylvania Carey Law School, and I am an academic director of the Quattrone Center. I'm here with Judge Darrell Jordan today to talk about some work that we've done on misdemeanor bail reform in Harris County. It's work that Judge Jordan has been involved in thinking about and advocating for positive change for a number of years. What I'd like to do is describe some results from some recent research that we've done at the Quattrone Center, which demonstrates some of the positive impacts of misdemeanor bail reform. And then Judge Jordan and I will have a conversation about the research. Our project is focused on an important question for the county. There's been a lot of debate and conversation about the impacts of bail reform. And of course, the county, with respect to its misdemeanor bail system in particular, has implemented some important reforms. And so the question that we were trying to tackle with this research is, what is the effect of expanding pretrial release for people charged with misdemeanors? And we were looking at not only what happens in their immediate case, but also future contact with the criminal justice system. And so we're going to focus on a set of reforms that began in June of 2017 in the county. And these reforms arose in response to a civil rights lawsuit that was filed by a number of organizations against the county, alleging that the processes that the county used at the time amounted to wealth-based detention and were not sufficiently individualized and therefore violated due process and equal protection. Before we talk about some of the impacts of the reforms, I think it's just worth stepping back and thinking about how the system operated at the time that this lawsuit occurred. So the majority of people who were charged with misdemeanors within some amount of time were brought before a magistrate in a video hearing. And magistrates largely followed a bail schedule, which had been promulgated in the county, which assigned bail amounts of between $500 to $5,000 for most defendants. And so if people were able to pay that amount of bail, then they could be released pre-trial. If they didn't have the money, then they would be detained. If you look in the data in the years immediately preceding the reform, about half of misdemeanor defendants weren't able to come up with these small amounts of cash in order to secure their release. And so they were detained pre-trial. If you look at the numbers, about 34,000 people per year on average were being detained. Again, for these low-level offenses and offenses where if you had relatively small amounts of money, you'd be able to be released. So as a result of the lawsuit and a federal injunction, the county was required to release people who would be assigned some bail amount under the bail schedule, but who completed an affidavit saying, I don't have the money to pay the bail. Now, it didn't actually get rid of bail. They just released folks on unsecured bail. So the main difference of this part of the reform was that rather than forcing you to pay up front and detaining you if you didn't have the money, the default would be we're going to try and release folks. And there were some carve-outs for certain categories of offenses, for example, domestic violence. And the reform that was begun by the federal court ultimately was incorporated into local rules and as part of the settlement of the O'Donnell lawsuit. And so that reform that began with this injunction that we study is one that's persisted with some minor tweaks up to the present. And importantly, this is a reform that only applied to people who were charged with misdemeanors. So to study the impact of this, we worked with the county and the Office of Justice and Safety to combine data from a number of county agencies. We ended up with a fairly rich administrative data set that includes over 500,000 cases from 2015 to the present. We think that these are some of the best and most robust data that would be available for trying to measure the impacts of the reform, recognizing that all data sources, and particularly criminal justice data, have various limitations. To understand how we measure the impacts of the reform, let me just show you some raw data. So this gold line is the fraction of people who get released within 24 hours. and we give averages for people who are charged with misdemeanors. And what you see is at the time of this injunction, there's a very abrupt increase, right? We have all of a sudden, previously about 54% of people are being released, and all of a sudden that jumps up to almost 70%. For people charged with lower level felonies, the blue line, we don't see a corresponding change because, of course, the reform was focused on people who are charged with misdemeanors. So if you think that expanding pretrial release would, for example, allow people who might have pled guilty due to being in pretrial detention have an ability to fight their case and actually avoid conviction, then you'd expect, if we were to look at conviction rates, to see some sort of a shift in the data. And that's exactly what we see. So if we look at, say, the likelihood that someone is convicted, right at the time of the injunction, we see an abrupt shift. Now, some people have claimed that bail reform is going, if we release people sooner, then they're going to go on and commit additional crimes. We can look at the raw data and see if we see some sort of a pattern, some sort of a shift at the time of the injunction when all of a sudden we were releasing more people. And in the raw data, in fact, you don't see any evidence of that, right? So if liberalizing pretrial release increases crime, what you'd expect to see is right about here, all of a sudden there's some sort of a jump. And in fact, we don't see that at all. So we did an exhaustive analysis accounting for hundreds of contextual variables, doing a lot of checks to make sure our results were robust in various ways. Let me just describe some of the key findings from our analysis. First of all, the data suggests that and demonstrate that misdemeanor pretrial reform was beneficial in that it produced more lenient outcomes and reduced the system's fiscal and human costs. Our estimate suggests that the rates of people pleading guilty fell by about 15%. About 9% of defendants avoided conviction as a result of the liberalized release under the injunction. The likelihood of a jail sentence fell by 17%, and sentence length fell by 15%. If we look across different subgroups of the defendant population, we see that these benefits were shared widely. If we look at different age groups, by race, ethnicity, across different neighborhoods, and even if we look at people with prior involvement in the system. So one thing these results suggest is that there was a ratcheting back of some of the fiscal and human costs associated with the misdemeanor system as a result of this reform. Well, critics of reform raise two potential concerns. They say, well, hey, if you release people early, they're not going to show up for court. And so that's going to be a problem. We looked at that, and to measure whether people show up, we used a proxy, which is, are we actually ultimately able to resolve the case? One of the main concerns with people not showing up for court, of course, is that we think that it's important that if someone is accused of a crime, that we ultimately can resolve that case and adjudicate it or dismiss it. And so we think that a logical thing to think about if you're concerned about non-appearance is, at the end of the day, are we actually able to conclude the case and come to a resolution? Although we did see some measurable increases in case non-resolution as a result of these reforms, they were very modest. So without pretrial reform, ultimately over 99% of cases resolved successfully. This goes down to about 98% with pretrial reform. Our best estimate suggests of the people released earlier under the injunction, maybe around 7% ultimately didn't have their cases resolved. So that's not nothing, but it isn't a huge failure rate. It's not large numbers of people who ultimately are avoiding adjudication of their cases. And that 7% number is on par with pretrial systems in other jurisdictions that are viewed as being quite high performing. So the other major concern that people raise about expanding pretrial release is that people are going to go and commit more crimes as a result. And so we carefully looked at that. And our analysis suggests that there's just no evidence that expanding pretrial release for this category of misdemeanor defendants fueled a spike in crime. If we look and count up the number of new cases people get 1 year after their initial case, we don't see any evidence of a statistically significant change in crime. If we look further out to 3 years, 4 years, even 5 years, we actually see a statistically significant measurable decrease in crime, which is to say, by expanding pretrial release, ultimately people have less contact with the criminal justice system. We found with our preferred estimates about a 6% reduction in overall new cases and about a 9% reduction in felony cases. And that's a result that's consistent with some of our prior research for Harris County, and that has been confirmed in other jurisdictions. So the bottom line here is, the research suggests that detaining people, particularly those charged with misdemeanors pre-trial, has a number of drawbacks. It can distort the guilt-innocence determination, generate significant human and fiscal costs, and it doesn't really improve public safety. And so the reform that Harris County has begun, which has liberalized pretrial release for those charged with misdemeanors, has yielded substantial community benefits. It's at the same time preserved accountability and public safety, and it's a reform that I think other jurisdictions thinking about pretrial reform should consider. For those who are interested in the full study, here's a link and a QR code. So those are some of our key results. I'd welcome, again, as someone who's been, kind of a thought leader in this space in the county for a number of years, I'd be very interested in your reactions, Judge Jordan.
Well, it makes me smile. It makes me happy to know all the work that the judges, myself, put in and coming up with this Rule 9 and part of the settlement, that they're working. Our primary goal was to follow the Constitution, to make sure everyone was treated in a fair manner. And the studies that keep coming out about our system show that regardless of race, people are being treated the same. Regardless of financial status, people are being treated the same. And that's what we wanted to do. The originals, I call it the Heaton study. So the original study that you did showed a lot of racial disparities in sentencing and release. And as a person who has taken an oath to follow the Constitution, that just didn't sit right with myself or any of the other judges. And so we keep getting reports from the monitor, and now with your really exhaustive research, it makes us feel good inside, and to know that is having a positive impact on community safety. Community safety is like a buzzword right now all across the country. Everyone talking about safety, spike in crime. And so to know that our system is helping to lower those numbers as well as save the county. The last number I heard was $30 million. And we have visitors come from around the United States. I've been all over, from California, Florida, Memphis, Chicago, speaking about our system. And that's the beauty of making change in Harris County, which is larger than 27 states, is that if it works here, it can work anywhere. And so I am really thankful for all the research that you and your team have done. And I think it's incumbent of anyone who operates a system like us to have it open so people can come and check and see what we're doing. And we're not doing this in secret. We're not embarrassed about our work. We don't try to hide the numbers, because if there's a problem, then we need to address it, because we are affecting people's lives. And so I'm truly thankful for all the work that you and your team continue to do in this area.
Well, and thanks for those comments. And I would just echo the comment that you made about openness. I think one of the reasons that we're able to have this knowledge and this understanding is because the county has made data available and worked with us in order to measure the impacts of these policies. And I think the county deserves a lot of credit. I'm certainly excited to see what the future holds for Harris County. And I hope that the results of this research can help elevate voices of reform and change in the county, and also spur other jurisdictions that are considering ways to make their pretrial systems better to look at this reform and see if it's something that could work for them as well. Thanks very much.
Yeah, absolutely. Thank you.